Okay. All right. Well, good morning and happy Halloween. Today we're going to be sharing some very interesting transactions that I've throughout my years I've been privy. I don't know if it's a good thing or a bad thing, but I've been privy to be able to witness. As the broker of record for the office and been with KW for 12 years, I've had the opportunity to really understand the elements of real estate transactions. And, for the most part, we want all of our deals to go as smooth as possible, right? But in essence, sometimes things happen, situations occurs, and it could go quickly left field, right? So real estate deals goes wrong. The true transaction nightmares and the lessons that protect all of us. My number one priority is for all of you, to be protected, right? Because we are in a situation where a transaction can immediately escalate if a buyer, a seller, a developer, an investor doesn't see eye to eye. Our job is to kind of navigate that, right, to get it to the finish line. And sometimes deals fall apart, right? Either the buyer does not like the property after doing their, thorough inspections of the home. But whatever the situation is, we have to keep it neutral, right? And not take the emotional aspect of what we do, right? We have to take ourselves out of it and always look at your client's best interests, right? So these are not stories from the movies. They're a real case where agents, buyers, sellers face major consequences. Each scenario reinforces why diligent documentation and broker communication matters in protecting your license and your clients, and obviously the brokerage as well. Because I think um, that the importance is communication is the most important thing in anything we do, right? Lack of communications will get us in a hot situation, right? And ultimately do the right thing, right? Doing the right thing. And if you're unsure or something just feels that it's going sideways immediately, bring it to our attentions. We'll help navigate. The beautiful thing is 80 to 95% of the time, I can eliminate it, I can diffuse it, I can de-escalate it. But it's those certain 5% where we have to now take it to an attorney, right? And the beautiful thing is we have the umbrella of risk management that does provide that layer of protection in case we need to get legal advice. Okay, so you guys ready?
Yep. Yep.
Let's do this. All right. So the first case, a phantom parcel. Okay, so I remember we were representing the seller on this one, right? Seller owned both a residential home and an adjacent vacant land. So this was a very unique property because the owner owned the house, the single family residence, but on the side also had a piece of vacant land. But it had two different parcels. It had the APN number, right, of the house, the residential, and it also had the APN number of the vacant land as well. Okay. So, however, during escrow, title mistakenly included both parcels under one sales transaction. The deal ended up closing. So, what ended up happening, the listing agent went and the seller says, look, I'm going to sell my property, but I'm not selling this parcel, okay? Because he had an elderly brother, I believe, and it was a bunch of plantations and flowers, and that was kind of his way to relieve the strain and stress of, he had a medical issue, so he would go there and water the plants, harvest, and all that, and that was kind of his area where he would be calm. So part of the process was that the listing agent put it on the listing agreement that this was only the house that was going to be sold. But somewhere on the tax real list, right? It included both the house and also this lot, which was owned by the owner.
Mhm.
So part of the initial process when the agent went on the listing appointment, he put that and documented it on the listing agreement only the house to be sold. So I guess there was a fall of communications where escrow didn't pick it up, title did not pick it up, and ultimately what ended up happening was the deal ended up closing. Well, it gets even better. The deal closed and the buyer unknowingly became owner of both properties. Okay. Good for the buyer, right? The seller only discovered this error months later when the buyer received a tax bill for both the APN number. Okay. After lengthy legal negotiations, the seller had to repurchase their own vacant land, unfortunately, property that should never have been transferred. So you always want to verify legal descriptions, right? And make sure that all parties that are involved with this real estate transaction, that everyone is on the same page. This was a very unique situation that could have been prevented, but unfortunately, the buyer did not want to just give it back because they went back and forth saying, look, the intent, and we even showed proof to the buyer on the listing agreement that the intent was never to sell the property or the vacant land as part of the transaction. So at first, we had some dialogue because I remember being involved in the communications with the buyer's agent and ultimately trying to come to a resolution. They ended up going through mediation, but the buyer was so adamant, I own this property, I'm paying taxes on this, this is my property, I am not going to sell it, excuse me, I'm not going to give it back to you. So you want to make sure that when you're listing a property and asking the right questions with the seller is vital. Again, in this particular situation, our agents did the right thing. They documented it, but unfortunately, it still escalated into a mediation that ultimately it became a potential lawsuit. And what ended up happening, months later, the buyer and the seller became another transaction. So the buyer never really gave back the property back. So because this was such a sentimental piece of land for the brother, who was the brother of the owner that sold the house, he had no choice but to buy the property back. Which the property was free and clear. I don't remember the actual dollar amount that the property was. It was a small parcel, but it was still a separate parcel that had value, you know. So you always want to make sure that you're verifying all of the forms. And, if there's something questionable, please bring it to our attention. Sometimes getting second eyes will definitely help with these type of situations. It's one of those very unique that it doesn't typically happen, but I don't know how all this got, connected together where the land and also the house was sold as a package deal, So even with two different APN numbers, escrow missed it, title missed it, and it opened up a can of worms as well. Question.
Yeah, Simon, in this case, then, since our agent has documented that only the home was being sold, I'm thinking, seemed like the seller could have had some legal recourse.
Yeah.
Because he was all documented and stuff, and would have been within his rights to sue the buyer for not giving his property back.
100%. But the problem is, once the deal closed, transfer of ownership happened. You cannot reverse once property is recorded. So now you got to go through the proper channels. The only way to be able to reverse it is for the buyer to do a quick claim and releasing that piece of land back to the original owner. Well, that didn't happen. The buyer, in their belief, thought, this is my property, I own it. If you want it, I'll sell it back to you, which was bad in their position, in my opinion, right? Because who in the right mind would think that, the house plus the separate APN number was part of the package deal? So the buyer unfortunately took advantage of the circumstances because he had the leverage saying, I own it, I'm paying taxes, it's mine. I have documentation that says that I own it. And that's where the battle ended up happening. So be mindful, be very, very careful when listing properties, okay? And making sure that you're listening, because sometimes that owner may own a piece of an adjacent land or a back easement that is not part, and they still want to keep it. This is why you want to have those communications on a regular basis to make sure you're on the same page. Because again, as this particular parcel shouldn't have been sold as part of the package deal, and ultimately the seller ended up losing significant because one, they had to buy it back, which shouldn't have been the case. Okay.
Simon,
Yes.
does it really matter for how long they were paying the taxes? Is this a specific period, a grace period, or it didn't really matter in this case?
It doesn't really matter because we
Mhm.
could have been on this for months or even years. This ended up happening within a few months. I think it
Wow.
was like 2 months when the buyer got a supplement tax. I think that's how it ultimately was divulged, and realized, wait a minute, why am I getting a supplement tax on a separate APN number, right? So that's where it kind of opened up the can of worms, and that's when all of this happened. And then when doing research, yeah, the owner who owned the residential house also was the owner on title of that piece of land too as well. So it could have happened immediately, because what happens when a transfer of ownership happens in the county recorders, within maybe 3 to 4 weeks, you'll see the update information. Now, technology has streamlined the process for the county recorders, but remember, the county has old systems. They're not as high in advance with their technology sometimes, so it takes a while before you'll see the updates. And that's exactly what happened, because this was many years ago when this transaction ended up happening. And um, but yeah, it started with the seller realizing that he was not the owner, and it was just an easy ask. Yes, listen, our intention was never to sell this property, so we're asking for you to just quit claim it back to us. And we thought, you know what, any moral person would do the right thing, right? But the buyer unfortunately didn't see it that way. I own it, didn't pay for it. Okay, didn't pay for it, and there was value. I think it was over $100,000. So it was one of those very unique situations that we, just as real estate professionals, want to make sure you're protected. The good thing is our agent, who was the listing agent, did so by documenting it, so this did not escalate to us. But I remember it was a very strenuous and stressful moment for all, because we didn't know what this was going to go in what direction. But this definitely could happen.
Thank you, Simon.
Yep. All right. So the next case is called the vanishing deposit. Okay. A buyer released all contingency. Check this out. True story. Buyer released all contingencies, then signed a cancellation instructing escrow to release the funds to the seller. Less than 24 hours later, the buyer had a second thought and attempted to block the disbursement. What should have been a significant, straightforward transaction turned into a 45-day nightmare. So, interesting thing, we represented the buyer. And we went almost to the finish line. At the very end of the transaction, as we were about to close, the buyer got cold feet. But the buyer also released all contingency. They went through the whole process. They did their physical inspections. They ordered an appraisal. They got their funding ready, and it was a slam dunk. But during that time, something happened where the buyer decided they wanted to cancel. And we were all like, when it was brought to my attention, is like, well, the buyer's in breach of contract here. Literally, the buyer went through the motions. The buyer released any and all contingency, physical inspections, seller disclosures, appraisal, and even the loan contingency, any and all. And then within days from that, the seller decided to cancel. And the seller was prepared to literally release the deposit to the seller.
Mhm.
Okay, and it was 3% of the purchase price. I don't remember the amount. I think it was $40,000 gone. And the seller, when signing the cancellation, right? There's sections on the cancellation that says, "Hey, what is the direction you want with this particular cancellation?" She ended up signing, released the deposit to the seller. Okay. Well, that's part of the process. You know, this is why buyers put money in good faith that if they don't perform, the seller has some recourses for damages, right? Because as a seller, I would not put and tie up a property if someone didn't have any skin in the game, right?
Right.
This is why we ask for initial deposit, right? So the seller, the buyer went through all of that and sent the cancellation. The agent ended up sending the cancellation to escrow. Escrow prepared their cancellation form and then sent it out to the seller and the listing agent. Less than 24 months or 24 hours, I should say, the buyer had a change of heart. And the buyer says, you know what? That's a lot of money that I'm going to lose. So ask the buyer's agent to send out an email saying, we retract what we originally said. And because escrow is a neutral party, their obligations and duty is to the seller and to the buyer. And because of that, escrow did not want to be in a liability situation. So they stopped and says, look, there's a dispute. We're not going to do anything but hold until you guys come to an agreement. But remember, the buyer not just released all contingencies, but also breached the contract as well and sent a cancellation to escrow saying, release the money to the seller. So day one, buyer released all contingencies, not necessarily day one, but the actual process. And I apologize. Buyer changed mind and demands deposit back. Immediately, escrow freeze and funds pending dispute resolution. And that's the proper way. When there's a dispute, then the ultimate thing for escrow is to be that neutral party and says, okay, until you guys come to a mutual agreement, I am not going to do anything or not even release the deposit. This ended up taking 45 days later, and you would think that because there was a dispute, the seller had every right to challenge and says, you're in the wrong, I'm in the right, you breached the contract, you released all contingencies, you also sent a cancellation authorizing escrow to release the deposit back to, not back to me, but to, to the seller. And then there was that stop and hold, right? Well, again, back and forth because we couldn't come to a resolution. What can you do next in these critical situations? Well, that's why you sign the form that says, mediation and arbitration, right? So immediately you can mediate this. Well, both didn't want to mediate, not the seller, not the buyer. So what happens? The money stays in escrow. So we said, what about doing and escalating it from taking away from a mediation? Let's just go right into an arbitration. They didn't want to do it. Then it got to the point where the buyer went radio silent. They were not communicating. And we were pressing for time, but there was nothing. Our hands were tied. The buyer's agent couldn't reach out to the buyer. I couldn't reach out to the buyer. The listing agent and the seller saying, what's going on? Well, the next step is for you to escalate this and maybe ask for a mediation or apply for an arbitration hearing, right? Well, all of this ended up happening 45 days later, right? Well, what ended up happening, escrow receives a conflict instructions, right? That must be hold the funds. Never assume funds will be released immediately, because of this. You would think automatically, slam dunk, it's a slam dunk deal. The listing agent is having conversations with the seller. We should be getting damages and the $35,000 deposit. Well, Here's a prime example that it didn't happen that way. What ended up happening, the buyer recovered 90% of their actual deposit back. So they ended up just hoping to put something on the wall and hope that it sticks. And that's exactly what they did, because the seller did not want to continue carrying on this issue. They needed to sell the property, but they didn't want the burden that this buyer would come back and try to sue, because they didn't have a mutual cancellation. So when the buyer proposed a offer, the seller says, you know what, it's not worth my time and effort and energy. So they agreed, and 90% of that money went back to the buyer and 10% went to the seller, and everyone signed the agreement and we were done. How about that?
That's great.
Okay, true story.
Crazy.
Okay, so remember, as a real estate agent, right? As a real estate agent, you can be in these so-called situations that it could happen. You might be on the seller side, you might be on the buyer side. There's no slam dunk black and white. That's the beautiful thing about real estate deals, but it's also the unfortunate. Now, I still want you to do the right thing, right? Because you want to document this, because the seller had every right, every opportunity to file for the full deposit. They were in the right. And anyone that would listen to this case would say, yeah, this deposit shall go to the seller. But they chose not to. That was the situation that could easily went immediately the other way for the seller. The seller would have won this case automatically, because there was just a lot of evidence against the buyer, right? So in essence, remember, even if you're in that predicament where you're the buyer's agent and the buyer releases any and all contingencies, doesn't mean it's the end of the world. I do not fear stuff like this, because I've seen it firsthand. Because escrow needs to do the right thing. They cannot just unilaterally just release the money just because the contract says that. This is why escrow protects themselves, because escrow's job is to see both and agree to both terms, right? That's why we have in the purchase agreement joint escrow, right? Because it coincides with the terms and conditions of the purchase agreement. So if there is not a meeting of the mind, a mutual understanding, then everything freezes. Okay. So then what do we do in these type of circumstances, Simon, where, they're holding the money hostage when either the buyer needs to get the money back or the money should be going to the seller? Well, the next would be is to escalate it into a mediation. The California Association of Realtors, your local association of realtors, have mediators that are licensed to mediate situations like this. And their job is to put both parties in two separate rooms and then bounce from one to another to come to some resolution. And I've been in many mediation cases, and even mediation sometimes don't go what you think, and it's like, that was a waste of time. The longest mediation case that I remember being on was like 9 hours, literally 9 hours. And thank goodness it was in a beautiful high rise in downtown Los Angeles, and they had snack for us. I felt like a jury. I literally felt like a jury. They had us housed, and I was there with our agents and our clients, and the attorneys were going back and forth. And I could walk out, stretch a little bit, and then go get some snacks, because they knew, and the buyer and the seller ended up paying a pretty penny just for this mediation. And I see why, because it was a beautiful location in the heart of downtown, overlooking all of downtown, up somewhere on the 15th floor, right? But they had all the goodies and snacks. So I was good, but it literally took almost 8 to 9 hours. And we still couldn't come to a resolution. That situation escalated into a lawsuit. Mediations, the whole purpose of that is to avoid a lawsuit, right? It's okay, let's come to some agreement. Let's talk. Let's come to some negotiations. That's what mediations is. So unfortunately, in this particular situation, the buyer ended up winning. Even though everything was against the buyer still won 90% of the money. So think about it. On a $10,000 deposit, 9,000 went back to the buyer and $1,000 went to the seller. And the seller was okay with it. That's the ironic thing. They didn't want to continue hassling. You know, if a seller was stern and stubborn, well, we still continue fighting, right? So that's something that can happen.
Simon, so I mean, I understand that. So why, if you had a contract signed by both parties, why is that is still no, the buyer was able to win? So what you're saying is that it doesn't really matter what the contract says. You can still go fight for what you think, it's the right for you.
So to answer your question, 100%, the contract is the contract, and it really defines on the situation, right?
Mhm.
The contract is instructions, instruction for the buyer, instructions for the seller, instructions for the agents. But when there's a dispute, right? And disputes happen all the time. Yes, Claudia, it should have been a situation where the money should have been released to the seller. But remember, escrow is a neutral party, meaning they get instructions from both. If someone says stop, we're not going to continue. Well, escrow needs to stop, even though one is saying it, it's not mutual, but someone is actually enforcing that. That the job of the escrow is to uphold their client's wishes, which in this case, it's both the buyer and the seller. So they have to uphold requirements and the process. And because the situation, as clear as it is, that the buyer released all contingency, the buyer within 24, less than 24 hours decided not to do so. Now, if the money was already released, right? Let's say that the buyer 48 hours later, reaches out to escrow and the money has already been released, then there's really not much that the buyer can do at that point because the money was already released. And escrow at that says, well, we got the contract and ultimately we ended up releasing the money. But remember, escrow has an additional step. Just because we send a cancellation, escrow still prepares their own personal cancellation. So it reinforces not just what mutually agreed between either parties or if there's a dispute, but also to reinforce, escrow will send an additional cancellation. This is why we have an addendum, and then escrow prepares an amendment, right? Because they just want to cover their bases. They don't want to be sued, because when we are talking about real estate and more so deposit, and deposits can be significant, escrow doesn't want to be in a compromised position that they accidentally release the money to the wrong party, right? Because then that puts them in a liability situation and they could be sued. So in this instant, the buyer immediately, within that time frame, instructed and sent out a request, and that put a stop to escrow from continuing to release that money. If they would have waited another several hours, who knows? That money could have been released to the seller. But in this instance, it didn't happen, and we ended up staying in this for 45 additional days until a negotiation started. Now, in this case, remember, a seller could also escalate this, meaning just because the buyer put a request to hold on releasing the money doesn't necessarily means that the seller's hands are tied, right? Well, the seller can then immediately hire an attorney, send a demand, or do mediation, which is, again, what the process says. This is why it's important, folks, that you're documenting everything. And when you're getting offers and you're the listing agent, make sure that the buyer is signing mediation and arbitration, the initial aspect of it. Because if there is no signature, then it's not an agreed upon term. And that's where a lot of people may have that exit, right? Or the opportunity to avoid a mediation or avoid an arbitration. So that is a condition. And I would reinforce, well, I don't want to initial, I don't want to go through a mediation. Okay, then your offer may not be considered. Okay, because we want to be on the same field and make sure that we're going through the process, right? And the end goal is obviously to close the deal. But we just never know when these deals fall apart. It may go sideways immediately. Does that make sense?
Yes.
Yes. Thank you.
You're very welcome. All right, let's continue to scenario number 3. All right, so this is the serial killer,
Hmm.
literally, okay? When the past hunts a sale, okay? An investor purchased the home through a wholesaler, okay? So the property was bought. So property was on the market. It was a fixer, right? Property was on the market. A wholesaler ended up tying up the property, and that wholesaler ended up selling it as an end user to the buyer, who was an investor that was going to close on the deal. Okay. So through the wholesaler, renovated a beautiful and resold it to an unexpected buyer, right? So ultimately, what happened was the property was for sale. A wholesaler tied up the property and then try to find an end user to ultimately close. And you got to be very careful with wholesalers, because these wholesalers are not intentionally buying the property. They're tying up the property with the intent to sell it to an end user that will close. Okay. So that's exactly what transpired here, where the wholesaler found and identified a buyer who was an investor. That investor ultimately closed on the deal, but was provided very limited disclosures. One, they didn't know that a particular individual used to own this property. Okay. So, so the unexpected buyer, after closing, a neighbor casually mentioned that a serial killer once lived there. After doing their research, confirmed the horrible truth. Okay. So the killer and spouse owned the property back in the 80s. Okay. So the husband was later convicted with DNA evidence and ended up passing away and dying in prison. The property had sold multiple times with no mention of this event. So the husband and wife, who was a serial killer, um, owned the property in the early 80s. He worked for the city of Los Angeles. He worked for the waste department. This
Oh,
was a
wow.
property in South Central. Okay. Well, when he was convicted in the early 2000s, the wife ended up still staying in the property, still owned the property up until 2014. So in 2014, that's when the wife sold the property. Now, from that point, it was sold multiple times until our client, the buyer, the investor, ended up buying it a year ago or 2 years ago, if I remember correctly. So we don't have any history if any of those individual sellers that sold the property ever told the buyer that this property was a stagnant property that should have been disclosed. Now, no one died on this property, okay? No one died on the property. It was just that this individual was convicted of murdering people. And when I did my research, sure enough, it was the individual that owned this property. So in essence, as real estate professionals, okay, the importance of the stigma of a home is, if it's newsworthy and you know about it, that's an immediate disclosure that we must disclose, folks, because there is there is possibility that someone is going to end up telling you. And that's exactly what ended up happening here in this particular situation, where the neighbor said, hey, by the way, did you know that so-and-so lived in this property? So-and-so, they didn't know who so-and-so was, but they started doing some research. And to their shock and believe is, oh my gosh, I would not have bought this property if I knew. One, there's sometimes people are superstitious, but also the stigma of the value, right? If they know that this property was owned or a murder happened, my property is not going to be worth more because of this. People are superstitious, unfortunately. So the buyer filed, the buyer filed a disclosure complaint, citing that it was a psychological stigma and lack of transparency. And the case drags the entire chain of ownership into litigation. So ultimately, it's still a pending litigation as we speak.
Mm.
But when we reached out to the agent says, I was not aware. The agent reached out to the investor who bought the property that eventually became the owner. They said they didn't know. We didn't get anything. And I looked at the disclosures, the TDS and the SBQ that were provided, and nowhere on that disclosure said anything about this. So we don't even know if any of this was said through past buyers and sellers. The essence is this can happen and this can put us in a very compromised position. Now, the buyer ultimately put a lawsuit against the seller for non-disclosure that they believe that the seller knew about it and failed to disclose. Okay. The seller disagrees, hired their attorney as well, and says, no, that was never the case. I was the wholesaler, excuse me, I was the buyer that bought it from this wholesaler. I was never provided any evidence. Well, the problem is this can happen. And this is exactly a very sensitive situation that can happen to any of us.
Mhm.
So you want to ask those questions, right? And more so is when I'm sitting down with the seller and explaining the SBQ or the TDS, I really go deep into that conversation and I play that investigator mentality, meaning because people are going to forget. People are not going to remember until something triggers them. But I rather overly kill and disclose than under deliver and non-disclose the situation because I thought, you know what, that happened a very long time. Now, with that being said, folks, and this is again people on Zoom, if the contract says the SBQ says that if anyone has died in the property in the last 3 years, right, you must disclose. So from the time you put the property on the market, 3 years back, you must disclose if there was any death on the property. Now, this situation, he was convicted in early 2000, right? They didn't own the property when the buyer bought it, right? But let's just say that you were the listing agent that ultimately listed this property and that information was brought to your attention, right? And you're thinking, oh my gosh, I don't know if I'm going to be able to sell this property if they know that this was a newsworthy event, kind of similar to the Night Stalker back in the 80s, the Richard Ramirez case. Kind of the same scenario and situation, right? Well, I think that this property for the rest of its entirely until it stays there, it's going to have to be a disclose, even though that this happened many, many years ago. Here's a prime example of what can cause a situation where now we're entangled in a litigation and lawsuit, right? So I'm fair warning all of you is you got to ask questions. Do you know anything? And I always say, does your neighbors know anything about the area, right? Because the neighbors are the ones that know. You might have neighbors. I'll give you an example. Just moved into my place less than a year ago, and I got neighbors to my right and neighbors to my back, and to my right and to my left. I don't have any neighbors really behind me. So my neighbor to my right has been there since 1975. My neighbor to the left has been there since maybe mid-90s. So they have history. My neighbor on the right tells me everything. He knows more about my property than I knew from the owner, because he's been there since 1975.
Mhm.
I didn't know that my property had mineral rights.
Mm.
And after doing a due diligence, I closed on the deal, didn't even know until he says, by the way, our properties have mineral rights. Have you looked into, I says, looked into what? To see if your property has mineral rights. I don't remember the seller. So I researched, I didn't see anything that said about mineral rights. So I ended up reaching out to my title person, and title says, let me do a dive deep history search. They ended up going back to 1930s. the 1930s. And if you know what mineral rights are, those are transferable. And you don't have to transfer it with the sale of the home. You can sell the real estate, but keep the mineral rights. So he says you might have interest where you're getting royalty from the oil company. So I says, interesting. Okay. So went to my title guy, and he sure enough did a thorough background, and sure enough, this property also has mineral rights. And I says, who owns those mineral rights? Well, let's double check. So never was it transferred. So what happens is that it was never transferred to any individual. It transfers to the new owner. So guess what? I own those mineral rights of the property. So again, if I ever in the future decide to sell, I have the right to retain those mineral rights, not sell that, but sell the real estate, right? So pros and cons, but the essence of it, your neighbors know a lot. Okay. And this is exactly what ended up happening, that the neighbor reached out to the current buyer and says, hey, did you know that a serial killer lived here? That's where it started the can of worms and started this situation. So be very careful. Yes, Afshin.
So what if that property gets demolished, like this 1980s? The serial killer property gets demolished and then rebuild everything. Still, do we have to disclose it, or that ends the whole story?
That's a very good question. And whoever I didn't see who put it was the grim sleeper. It was the grim sleeper. So he was he worked for the city of Los Angeles.
South on Western.
Yeah.
Remember that?
Yeah. I think the property is on I think it was on 82nd Street or something. Anyways, but yeah, it is the grim sleeper. So unfortunately, this individual was killing, females.
Yeah.
And basically dumping them in the trash bins. And he worked for the waste company. Interesting story. But going back to your question regarding what if the property gets demolished? Okay, that's a very good question. Here's my thought around that, because everyone is going to have their own individual theory, I guess, because the land is still the land, right? The parcel is still the parcel. Even though there's a new construction, that property is still sitting in the same, right? In the same parcel that the previous home, right? You can look at it from two different angles, because I can tell you, here's my theory, right? And I'm looking at it from two different positions. Me as a individual homeowner and me as a real estate broker, right? I would still disclose. Okay, because I can care less that the property was demolished, just like the O.J. Simpson house was demolished. Guess what? It's still a stigma.
Yeah.
They will continue talking about, did you know that once upon a time, O.J. Simpson had a house here that was demolished in early 2000s, I believe, right? But the land is still there. People will still go there and says, this is where that scene in the early 90s. So in essence, this house and this land is tarnished or for the rest of it. Unfortunately, there's nothing that can change it, because someone will always think about that situation. Once upon a time, before this new construction, this home that was demolished was owned by a serial killer. So unfortunately, I see it as a way I would disclose it. Okay. Even
Simon,
though it's a brand new construction. Yes.
okay, for the agent, in the agent side, what the best search for the agent to find out this since a long time ago and no one discovered it for the agent, how he can find out the best resource?
Yeah, very good question. Your job is not to do the internal investigation, right? You're not going to do search and search and search to find out, if the home was built in the 1950s, you're not going to go back to the 1950s. All I'm saying is, when having conversations with the seller, you must dig deeper into those conversations. Does your neighbors know of any issues regarding the area, the property, any history, anything that brings to light that maybe we can disclose, right? Because for me, is the particular property that I bought, that home was built in 1930s. There's a lot of history, almost 100-year-old home that, throughout the years. And the beautiful thing about this particular home is that only two owners, I'm the third owner. So the previous owner lived there for almost 65 or 68 years, and then the original owners that bought it in 1930, and then in the late 40s or 50s, the second owner, which I ended up buying it from the grandson, because the grandparents were the ones that originally bought it, passed it on to the parents, and then the parents passed away, and then ultimately the children passed. I don't remember the whole chain of title, but the grandson was the ultimate successor to the trust. And yeah, so there was a lot of history. He did disclose a lot of things about the property, but it was interesting that he didn't disclose about the mineral rights until talking to my neighbor. And my neighbor was able to tell me all of the gossip and all the juicy stuff that was happening in the neighborhood that I wouldn't have known and was never documented. So in essence, as real estate professionals, ask those questions so that way it'll trigger that the seller is, you know what, because you made me think, I remember this happened. I'll share another quick story with you as well, is my parents. My parents own a house and they've been there for 35 years. But as a kid growing up there, I remember we have a pet cemetery in the backyard. I literally have 3 or 4 dogs buried back there. As kids, we didn't know. We didn't go to the dog shelter and backyard, baby. So we have literally pet cemetery back there of dogs. Now, God forbid, my parents, end up, passing as an example. I'm the successor to that trust, right? I can decide to sell the property, keep it as a rental, and do whatever I need to do. But the essence is if I do to sell, or if they decide to sell, right? I'm going to tell my parents, hey, don't forget, I would disclose that. Because again, people may see that as a situation of what's the word I was going to use? Not haunted, but superstitious. Even though as kids we didn't think, our dogs unfortunately passed. We had a decent sized backyard. There was a section in the corner. We dug and we put our pets to rest there. I mean, we didn't know as kids, The essence is something like that, I would probably disclose, right? I'll give you another example. A client many years ago, or an agent brought it to my attention. Hey, I have this scenario and I'm not sure how to, approach it. Okay, tell me more. So the owner owned a 1 acre property, and on the 1 acre property, beautiful home. He didn't have neighbors to the back, and his backyard was a hill. So the closest house was way, 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 way on top of the hill. But so he would use his backyard. He had it all set up with his little artificial green, and he would hit golf balls. He would literally hit golf balls like a range. And the agent says, look, he says that there's probably thousands of golf balls in the backyard. Should I tell him to disclose that? And I said, absolutely. Absolutely. The minute you talk about when someone says something to you, I would disclose. And then the agent says, well, why do we need to disclose that there's thousands of golf balls? And I said this to her. I says, the reason you want to disclose that is, God forbid, someone goes out to the backyard in a late afternoon and ultimately steps on a golf ball, loses their balance, and ultimately tumble and fall and hurt themselves, or worse, die. And then they find out after doing an investigation, there's thousands of golf balls, and we didn't fully disclose that. Guess what? They're going to come after you. Literally. Because that should have been a disclosure.
Yeah.
And even though the seller, after talking to the agent, the seller chuckled and laughed about it. Really? Do I need to disclose that? But after because I ended up having the conversation, because they were adamant about doing so. I says, well, you can do one or two things. You can clean up all the golf balls or disclose all the golf balls. You know, we're only protecting you. That's all we're doing. We're trying to protect you because you just never know. And you know, those hard balls are hard. And if you're barefooted or you trip or lose your balance and you end up, because it was a ravine and it was a steep ravine, beautiful property, beautiful backyard, but that's where he would hit all of his golf balls. And never did he would pick them up. He would just let them go. I would disclose that. Make sense? I hope that kind of answers this. Yeah. All right, let's continue. Scenario number 4. All right, scenario 4 is the fake seller and the desert deception. Okay, so an agent received a call from a seller wanting to list a 5-acre vacant land in the high desert. Red flags were everywhere, but they went unnoticed. All documentations were executed via DocuSign. The agent never met the seller in person. The property was listed. A buyer found, escrow open without incident until the real owner contacted title and escrow asking why his property was being sold. So, okay. This is one that is happening more and more and more, folks, okay? Remember, raw land, especially out there in the boonies, right? People own acres and acres of property, but it's untouched, right? They don't even have addresses. They just have their APN number. It's not even have locators, right? Where you know where your property line is, right? They just own piece of land out there. These clever individuals are targeting real estate agents with the intent to defraud someone, right? Defraud the buyer. So in essence, as real estate agents, we're super excited to receive a call from a seller that wants to sell raw land. So we do our due diligence. But the question here is, all of this has been through email. Okay, you never really meet the seller. You never make an effort to jump on Zoom. Everything is via email. And this particular agent ultimately thought, okay, you want to sell a piece of land? I have no problem. I'll send you the listing agreement. Listing agent, the listing agreement was signed and executed. The agent put it on the MLS, and ultimately that opened up the escrow because there was a buyer that was interested. Now, bear in mind, the property was at a super discount, but the agent was not really knowledgeable of raw land. So she didn't know what raw land is. It's not like your typical residential home, right? Where you do comparables, right? You look at bedrooms, square footage, the lots, any updates done to the property that will determine, you know, apples to apples. Raw land is raw land, right? And you can get properties for $5,000 up to $180,000 and more, right? So the agent listed the property, open escrow with the buyer. And then what happened is when escrow send escrow instructions to the property address, right, that was on title, the owner reached out because they received this package. What the heck is all this from this escrow company, right? So they immediately call, hi, this is John Smith. I got escrow instructions. Oh yeah, you know, thank you so much for calling. My name is so-and-so. You know, we're, you know, trying to get the process, and congratulations for opening escrow. Says, escrow? We never intended to sell this property. What are you talking about? Right? Well, that's where it started. So immediately escrow reaches out to the agent, says, hey, by the way, the seller says they're not selling the property. What do you mean they're not selling the property? Yeah, the seller says they're not selling the property. Well, we have a listing agreement. So immediately the agent calls the number, right? The number that they have on the so-called seller. Well, the seller never calls, but they text. Okay. They'll never answer your call, but they'll text you, says, hey, I'm busy doing something. What can I help you? Send me a text or send me an email. So they're hiding behind the scenes, you know, with the intent to ultimately defraud someone, right? Because what happens is if a not so good escrow company, just like the first case scenario, someone may drop the ball and intentionally send, you know, paperwork to someone else, because as soon as the seller says, oh, by the way, please send, you know, escrow instructions to this address, right? the escrow officer should verify and do their due diligence before they start sending out paperwork, right? Because it's happened in the past where the buyer decides to back out and ultimately the seller believes they're entitled to their deposit and it's back and forth. And I believe there's been incidents where the seller, who is not the real seller, ends up getting some financial gain from it, from the buyer's deposit, okay? Or worse, the property does sell and ultimately the buyer believes they own the property, right? And the deal eventually records it does own, but because it was not the actual owner, that typically may void the situation because it was not the real owner, right? And we've seen circumstances that may happen that way as well. So be diligent when it comes to your position in selling, especially land, okay? The way you can position yourself is anytime someone calls you about listing a land, immediately get that gut feeling, okay, I should do a little bit more investigation, because if they're not willing to pick up the phone or meet with you in person, right? Because usually when we go on a listing appointment, we usually go on a listing appointment in person, right? But when it comes to land, high in the high desert, right? We're probably not going to go over there and meet with someone. Make an effort to have them come. Hey, I would love the opportunity to meet with you. I know you live out there in the riverside. We can meet somewhere halfway, right? Because then you'll know if this individual is legitimate, right?
Mhm.
And if they're not willing to meet, then that should tell you something. Be on the lookout. Okay. Always verify client's identity through an in-person or via video meeting before executing a listing paperwork. Review grantees, vesting names, and confirm property ownership and title. Protect yourself and obviously protect the brokerage. All right. Real quick, next one, the tenant and the landlord and the 300,000 claim. Okay. So this is a situation that can happen too, and you got to be very, very careful. An agent helped lease a property, and then eventually the owner decided that they wanted to sell the property. But then the landlord asked the agent to serve a 60-day notice to the tenant to vacate, because their intention, they wanted to lease the property, but eventually they changed of heart, says, I think we want to sell the property after all. The agent complied, stepped outside their scope of authority. The situation deteriorated rapidly. The tenant left the property, but claimed harassment. The landlord failed to provide timely deposit account or refund. So they decided that because these individuals were giving them a hard time, that they were not going to return the deposit back to the tenant. So that's number one, a no-no. The tenant filed complaint alleging emotional distress and violated of landlord-tenant law, and a $300,000 claim was filed against the landlord, agent, and the brokerage. Okay. So in essence, that's where it starts. Not that we're just going to write a check for 300,000 because the tenant feels emotionally harassed, but attorneys will take these all day long, folks. So remember your position as a real estate agent, right? You're not in the property management. Okay. You're not in a position to serve. That should be the owner or their own property management, not you. Okay. You can lease property, you can find a tenant, you can help a landlord rent their place, but do not practice any type of serving paperwork to any individual, because that will compromise your position. Not that the agent did anything wrong, because even just serving, hey, I'm just serving you from the seller. Ultimately, the decision is the seller wants to sell the property, but in essence, that also can drag us into a potential claim and situation, right? And the essence is, remember, tenants are very sensitive and they'll try to put a claim in a lawsuit. And there's attorneys out there that won, similar to like Section 8. Remember, Section 8 is one of the most notorious situations that is happening right now. There's ambulance attorneys out there that are just chasing real estate brokerages and agents that break the violation of Section 8. So you got to be very careful. When someone calls you asking that, does the landlord accept Section 8 vouchers? The answer is yes, please submit your application, right? You got to keep it very neutral.
Yeah.
So the case remains pending with broker and agent still a name in this complaint. All right, do we have someone? So yeah, that was it. David Franklin, aka the Grim Sleeper. Yep, the O.J. Simpson. Thank you, 1998. Okay, so thank you, Robert. I thought it was early 2000, but that was in 1998. We have some historians in our training today.
Simon, I have a
Yes.
question.
Yes.
So how do you find out if you have mineral rights in your property?
Through title. Title will let you know if you have mineral rights. So when title does a deep dive in a title search, depending on what year the home was built, ask title to go as far as possible to the original owners, and then on title it'll show that if the property has mineral rights.
Thank you.
Okay, welcome. All right, so common theme across all cases, these 5 scenarios are critical that every agent must recognize and avoid. Understand these common threats is the first step in protecting yourself, your clients, and the brokers from devastating consequences. Failure to verify, identify property data, ownership details were not properly confirmed before proceeding. Disclosure error, sellers omitting known material facts or agent failing to advise proper disclosure and protocols. Escrow, right? Conflicting instructions and premature improper release requests causing fund holds and lack of documentation, critical conversation and agreements not backed up in writing or retained in a file. And then the scope, agents stepping up and beyond their license authority into property management or legal territory. So again, just to caution you the importance of what you should be doing. And then broker best practice, your protection and checklist, title reviews, escrow coordination, disclosure oversights, client verification, landlord-tenant separation, is the importance. Remember, do your due diligence because you never want to be involved in a litigation. It's not fun and it's very stressful. And sometimes, there's monetary damage too, and yes, we do have errors and omissions insurance, but you still have to pay a deductible if you're ever named in a lawsuit, and more so if we have to write a check. Okay. And what else do we have? When in doubt, reach out. Okay, so if you have any doubts whatsoever, your broker is your first line of defense against compliance issues, legal exposure, and costly mistakes. The policy exists to protect you and your clients and the entire brokerage. Report red flags, right? And most of you are really, really good at doing so. If something doesn't feel right or you're uncertain, don't pretend to know. Say, look, I don't know the answer. Let me do a little bit of research. Let me get with my office. Let me talk to my broker. Let me talk to my team leader. Let me talk to someone that might be able to give me better advice or an answer. That's always going to be the best policy. No deal is worth the risk, right? No commission sales or listing is worth risking your license. Trust me. People have lost their real estate license. They've got it suspended, revoked. And if this is your livelihood, folks, do not take shortcuts, right? That's the important things, right? Because any little situation that the Department of Real Estate believes you were involved in some type of fraud or misleading or incompetent in navigating that, and they find you guilty to it, well, as fast as they can give you a real estate license is as fast they can also revoke your real estate license, okay? So always do the right thing. And then last is thorough diligence and ethics and accountability, right? So make sure that you are always verifying and making sure you document everything, because you just never know. You cannot remember a real estate transaction that happened 6 to a year or 3 years ago. That might come back to haunt you. But what you do have as a line of defense is the paperwork, right? This is why we're sticklers of having a checklist, sticklers that we want you to have all the paperwork in order before we release your commission check, because you just never know if any of these transactions come back and they feel that there was something wrongdoing, that they are now doing an internal investigation of the transaction or the individuals involved in the transaction. And because your name is on these documentation, that's open to anyone, right? If an attorney or the courts are asking for or subpoena your information, well, it's a court order. We have to comply by that, so I rather make sure that everything is in a line and that I'm not missing anything, because you just never know. With that, that concludes our class today. Any questions, thoughts, or concerns?
Yes.
Was this? Yes.
So, two questions. So as a listing agent, do we have to always ask if there was any death in that property? Even though it's not pleasant to ask, but still we ask regardless.
Repeat the question again. I'm sorry.
I said that, so as a listing agent, do we have to always ask the question related to death in the property?
So the document that you provide, the seller disclosures, the TDS and the SPQ. On the SPQ, there's a section that says, seller, do you know if there's been any death on the property in the last 3 years? Okay. So the questions are already embedded on the form. The form is going to have those questions. And if the answer is yes, there's a section that talks about, please give us an explanation. Now, if a death occurred after the 3 years, you don't have to disclose. Okay. But let's just say you're hosting an open house on your listing and a buyer on a direct question to you says, hey, Afshin, did anyone die on the property? Well, you're thinking, well, the disclosure says I have to disclose anything within 3 years, right? So your answer is not going to be no. Your answer is going to be, yeah, someone passed away, over 3 years ago. Okay. Because it's a direct question, you must apply and do your due diligence by saying that there was a death on the property, even if it happened 20 years ago, 30 years ago. If you know someone died, yes, you don't have to disclose it on the SPQ, but on a direct conversation with you, then yes, you must disclose it.
Thank you.
Make sense?
Yes. Number two, regarding any contract, when we're gonna enter into any contract, is it a good idea to always ask for a proper identification card or something that we can, write down the information? Is that something that it's a good way of practicing real estate?
When it comes to like on a sale,
Both.
is that what you're referring to?
Both sale and purchase, yeah. Like, I'm gonna enter into a contract with the client and then we are ready to go. And now can I ask for a proper ID to write down everything, copy?
So the answer is no. You don't need to ask for ID, because again, just because the property title says John Smith and the license says John Smith doesn't necessarily mean that John Smith ID is the owner of John Smith, the property. So that's where escrow and title, they have to do their due diligence. Part of the process is, when they're doing the escrow instructions, they have to provide social security information, date of birth, and their license number information. They have the systems in place to identify if there's any potential fraud. If there's a fraud alert, they immediately know. Our job is not to know that. Our job is just to help sell the property, right? But it is as soon as something happens, then escrow or title will let us know. Christine. Go ahead, Christine.
Sorry about that. So I was just going to answer to that. This was great, Simon. Thank you so much for today. So if I'm meeting a buyer that I don't know, I have asked it for their driver's license or something like an ID. And anyone that I've only maybe had 2 people that didn't want to give it to me. And then there was some reason I'm like, I'm not meeting them. And so to me, that was like, I think nobody has a problem if they're legit. They're like, oh yeah, totally here, So that's what I've done before to answer that question. I do remember you telling that story about your childhood home, Simon, and I laugh because my family home had the same thing with probably 20 birds that were all each in a little metal box. So, those metal boxes didn't go anywhere. And so I always wonder what happened there. But anyway, that's it.
Yeah. Thank you. I love it. Great to see you, by the way, too, Christine. Thank you for being on the call. All right. Well, that concludes our contract class today. Thank you, everyone, for being on the call. This will be recorded. And again, be safe. It is Halloween, and go Dodgers. Thanks, everyone.
Thank you, Simon.
Go
Thank
Dodgers.
you.